let's go on the record on cause number DC 237743, Maidlow versus Hoffberg. Council, make your appearances.
Phillips for the plaintiffs, Your Honor.
Bailey Cherry for Elijah and Lindsay Hoffberg, defendants.
Let's proceed.
Yes, Your Honor. Today we're here on behalf of defendants' no evidence motion for summary judgment that we filed on behalf of defendants. We have alleged that we're entitled to summary judgment. There is no evidence of essential elements of plaintiff's claims. And those 5 claims are statutory fraud, fraudulent inducement, breach of contract, and unjust enrichment. In response to our summary judgment motion, plaintiffs are not disputing the elements as we set them out in our motion. However, they have failed to set forth even a scintilla of evidence in support of each one of the challenged elements of those claims. They haven't set forth any admissible summary judgment evidence to rise to that scintilla standard. And instead, they have alleged that there has not been an adequate time for discovery.
When does discovery close in this case?
Your Honor, this was reset to a November trial setting, so there's no scheduling order. We filed this before it was continued to November, Your Honor. So under the rules, it would have closed back in April.
Is this a level 1, level 2, or level 3 case?
Your Honor, I believe this is a level 2. Yes, Your Honor, it's a level 2 case.
And what discovery has been attempted so far?
And since they filed that continuance, that is my next point. They haven't done any discovery. They haven't sent discovery and they haven't taken any depositions since they filed their continuance back in February. And now it's almost August. And
have they attempted any discovery or no?
No, Your Honor, not since then. And they haven't sent any discovery requests either.
Before then?
No, Your Honor. And they did not file a verified motion for continuance in response to our summary judgment motion, which we would contend would have been the proper mechanism for them to continue this hearing if they believed.
Let's deal with it. Oh, I'm sorry, Ms. Cherry, go ahead.
No, I apologize for speaking over you.
Okay, so Mr. Phillips, is there any response on the continuance only?
Yes, sir, Judge. With respect to the motion, when we originally filed the motion for continuance, that was based on a medical issue that involved myself, and I advised the court that I wouldn't be able to conduct discovery in the run-up immediately prior to the trial setting. And so I was asking for a continuance that would be sufficient to allow us to conduct that discovery, hopefully over the course of the summer. And as counsel indicated, their motion was filed at a point in time prior to the continuance being granted. So my understanding is, based upon the continuance, that we still had plenty of time to conduct discovery, and an adequate time for discovery had not closed based upon the granting of the continuance motion.
Have you attempted any discovery, any written or requested any depositions on this case since it was filed over a year ago?
Yes, sir. On 2 different occasions earlier this year, I requested, prior to filing the motion for continuance, the depositions of the Hoffbergs and their named expert witness. Sent 2 different letters, never got a response to those letters.
Okay. He says he's just attempted discovery.
And Your Honor, we do disagree that we have responded. I believe there may have been a request in January for deposition dates, and I believe that we sent those over. However, they were never noticed. I'd be happy to go back and look at that, but we haven't received any written discovery requests, and they haven't followed up since. If they did send us deposition requests, it would have been in January or February. There has been no further discussion about that.
Response?
Respond, Judge. Yes, I did send 2 requests in January. I don't have a recollection of receiving any response to either one of those requests. And when we got into February and it became apparent that I wasn't going to be able to get the discovery done ahead of the April 28th cutoff, that's when I filed the motion for continuance.
All right, continuance is denied at this point. Let's deal with the merits.
Yes, Your Honor. So we would contend that they haven't set forth any evidence, and certainly not a scintilla of evidence in support of those 5 claims. And we would ask that you
So they
dismiss.
filed an affidavit attached to their summary judgment, correct?
Yes, Your
Yes, sir,
Honor.
Judge.
That's correct, Your Honor.
And what about the affidavit? Are you contesting that the affidavit is defective, or kind of what's the issue that you have with the affidavit?
Your Honor, I don't believe that the affidavit serves as a scintilla of evidence. They haven't properly attached any of the exhibits to that affidavit that they're relying upon. The affidavit is self-serving.
They attach a Texas Realtor seller's disclosure, right?
Yes,
Sir.
Your Honor. That's correct.
The
Okay.
termite inspection report.
Okay. So I guess go into, there's 5 claims here, right?
Yes, Your Honor.
What's
So
the first claim?
the first claim is for statutory fraud. And specifically as to statutory fraud, we don't believe that they have set forth any evidence of any of their damages sustained, which is element number 5. But we also contend that there's no evidence that we made any material representations, false material representations to them, which is element number 1 and 2. But really focusing on element number 5, there's just no evidence of any damages that they would have sustained as a result of any alleged
So
misrepresentation.
in the affidavit, it says that they disclaimed that your clients, I guess, disclaimed any knowledge on their part of wood rot or previous treatment for termites, right?
Yes, Your Honor.
And then I assumed at some point they spent $80,000 to fix termite damages. Is that right?
Your Honor, we would dispute that would serve as any evidence in this case. They haven't set forth anything to show that. And our contention is, and we would say this at the point of trial, is that those were just home renovation costs that they're trying to cloak under some type of.
That may be true, but that's up for a fact finder. So statutory fraud, the summary judgment's denied. What's the next one?
Yes, Your Honor. The next one is fraud and fraudulent inducement. Similar argument.
Same thing, denied. What else do you have?
Breach of contract, Your Honor.
Denied.
And then lastly, it would be unjust enrichment.
What's your argument on that?
That there's been no unjust enrichment here. There's nothing that showed that they had a valid, well, there's no evidence that defendants obtained a benefit from plaintiffs by fraud, duress, or the taking of undue advantage.
Response?
Your Honor, I think what their argument was in the actual pleading was that in the instance of there being a contract, there can't be an unjust enrichment. And really, all I was doing by including the unjust enrichment claim is pleading in the alternative, and would argue that the fact finder is entitled to determine if they decide there wasn't a valid contract, that there was unjust enrichment.
Is there any issue about whether or not there was a contract?
No, Judge, that contract exists.
Ms. Cherry?
Yes, Your Honor, we would agree that there is a real estate contract for the sale of the house.
All right, summary judgment's granted on adjustment enrichment. Ms. Cherry, go ahead and prepare an order on this.
Yes, Your
Nine, the 4 claims that have denied summary judgment on granting on adjustment enrichment. Indicate at the beginning, instead of on this date, say that this was heard on Zoom on July 29, 2024. Go ahead and share that with Mr. Phillips and get that to me by first thing in the morning, okay?
Yes, Your Honor, we will do so.
You have a great rest of your day, okay?
Thank you. May we be
Judge,
excused?
appreciate the court's time today. May be excused.
You may. And just so you know, you do have a trial setting coming up on 11/19.
Yes,
Yes,
sir.
Your Honor.
All right, you have a great rest of your day.
Thank you, Judge.
Mr. Faramond, are you still there?
Yes, Your Honor, I'm here.
Did you get a chance to talk to your client?
I did. Unfortunately, when he's available, I'm not available, Your Honor. Is it okay if we move this to next Monday?
Sure. Give me the cost number on this. Rhonda, are you there?
It's
Yes, Judge, I'm here.
Which one is it?
DC 24055526.
I'd say that again. DC what 24
05526.
and it's 24, right?
Yes, Your Honor.
Okay.
First side for
Yeah, go
versus,
ahead and reset that 7 days.
okay,
All right. And set it for prove up at 9 in the morning next week.
got it.
All right. So Rhonda, I know you had to do some stuff at the beginning. I just wanted to go through the docket with you just real quick so that you had everything. And
Okay.
you're excused, sir.
Thank you very much, Your Honor.
Oh, there's a
Okay.
Mr. Fandry here. Mr. Fandry, what are you here for?
Your Honor, I have a motion to compel. That's 9:30 on the motion docket.
All right, give me a second. All right, Rhonda. So 245614. Do you have that one?
I show no show, so
No,
DWAP.
no show, correct. DC 245625, 30 days. DC 245638, 30 days. DC 245702, no show.
Okay.
DC 245727, 14 days.
Mhm.
DC 245, I can't read my handwriting. I think it's 5795, 14 days. DC 245796, DWAP. DC 233803, we had a dismissal filed. And then do you have the rest?
Yes, I have it.
Okay. All righty. Next case we have on the docket is Hall versus Falcon Insurance Company. Or is everyone here in that case?
Dakota Andrew here for the plaintiff, Your Honor.
Eric Montrose here for defendants. I believe we're missing the second defense attorney.
Are they involved in this motion to compel?
Yes, Your Honor. The motion's actually against that defense attorney,
Who is it?
Lena Hinton.
You want to give her a call and find out? Is anyone here with Miss Hinton's office?
Yes, Your Honor. I'll go ahead and go on mute and I'll give her a call.
All right, guys, I'll be right back. All right. Any luck?
No, sir, Your Honor. I called and spoke to Paige at her office and was told that she was unavailable, but she was sending a message over to her. I asked to speak to anyone else, any assistant paralegals, anyone else in the office, and was told no one's available. I also sent an email to her with the Zoom link. She was included on the court's email that was sent on Wednesday as well. But I
What
sent her
law firm
another,
is this?
the Infinity Law Group.
What heard of them? Are they in Dallas?
They're in Houston, Your Honor.
Um, they're in what? Austin, you said?
In Houston.
Houston. It's up to you. Do you want to go forward or do you want to, what do you want to do?
It's a motion to compel on disclosures. So if she's here or not here, I think the court's result is going to be the same no matter what. She responded, but she did not, this is the car wreck case, and she did not produce the car wreck policy for the defendant she represents. And so that's all I need is just an order saying to give me the auto policy.
I will grant that. Let me see. Where did you already submit a proposed order or no?
I actually don't know, Your Honor. I can submit one
It
if I have.
looks like you may have. Let me see.
At the time that we filed the motion to compel, she hadn't responded to initial disclosures at all. She has since responded, so if I need to amend the order and just say that number 7 for the insuring agreement is granted, I'd be more than happy to do that.
This is Hall versus Falcon, right?
Yes, Your Honor.
Let me look real quick. Okay. What day did you file the proposed order?
Let me pull it back up. I believe it was in May.
There
like
it is.
May.
I see it 6. I see it 6/3. We go ahead and sign it right now. Let me just make sure it's good. Had I already granted a motion to compel on this on something else?
No, Your Honor.
Is this against Joe Shivers?
Yes, sir, Your Honor.
Okay. All right. I'll go ahead and send that in.
Thank you, Your Honor.
All right. You have a great rest of your day.
You too. Thank you very much, Your Honor.
All righty. Next hearing is Green versus Allstate. Anyone here in that case?
Good morning, Your Honor. I'm here on behalf of the plaintiff, Janet Green, with the Dick Law Firm.
Great.
Good morning, Judge Herbert Sanchez here, standing in for Layla Morgan, representing the defendant Allstate in this case.
Great. Tony, let's go on the record on DC 244178, Green versus Allstate Indemnity. Counsel, make your appearances.
Good morning. I'm Davita Green Norris here on behalf of the plaintiff, Janet Green, for the Dick Law Firm.
And good morning, Judge Herbert Sanchez, standing in for Layla Morgan, representing the defendant Allstate in this case.
Okay, let's proceed.
Good morning. This is the plaintiff's motion for motion to compel appraisal and abatement. This is regarding a pipe burst in an apartment in a renter's, or in a renter's place where they resided for personal property damage. And there was an insurance claim due to the damage that became a dispute over the amount. The policy provided for appraisal when the dispute is over the amount of loss. The plaintiff timely invoked appraisal, and I understand that the defendant does not believe that that was timely, but it was still within the statute of limitations. The defendant needs to name an appraiser and hasn't. They have completely not been party to the appraisal process. They refuse to participate in the appraisal process because of the timing. We believe this case should be abated and the parties compelled to complete appraisal because it's condition precedent so that we can determine the amount of loss. This doesn't have anything to do with the liability that can always be determined at another time. We acknowledge that defendant did submit funds early on in the matter, but then negotiations failed because there was more property damage that plaintiff does not believe that she received adequate compensation for. We do not believe that the plaintiff waived her right to appraisal. She never said that she wanted to waive, and this lawsuit was only filed after negotiations failed. So the scope of appraisal is for the damages, not for liability. We need to assess the amount of damage and leave causation up to the courts for later. And the cost of repair is what is at issue, and who is going to pay for it can be a later issue that is dealt with. But right now we need time to set aside. It's not for the purpose of delay. It's so that justice can be served. And we don't believe that this would prejudice the defendant at all because it's just to the amount of damage, not to liability. We ask that the court grant us time for an abatement until the appraisal process is complete.
Your Honor, we did follow our proper response before the court. Our course of argument is going to be basically that it was waived. This is actually a claim that was filed over 2 years ago. There was a payment made over about close to 35,000 for this. Is mainly this was actually a renter's policy dealing with only personal property inside the apartment. So at this time, we believe that it's not about whether she intentionally waived. Is by her conduct, by waiting over 2 years, she basically waived her right to appraisal. That's the main reason why we're in court. I think it would just delay the process if we go through appraisal.
All right. I'm going to go ahead and grant the request for appraisal.
Thank you, Your Honor.
I don't know what the basis. Are you asking for attorney's fees?
Just to reduce, or actually, we were the ones that filed a motion to request attorney's fees. We can disregard, Your Honor. At this time, we're not going to be seeking attorney's fees.
Okay.
Your Honor, we did request attorney's fees in the motion to compel.
All right. I'm not going to grant attorney's fees. It does say here that you want interrogatories to be due 30 days following the appraisal, 60 days. I'm going to put that 30 days following the appraisal award. Anything else today, guys?
No, Your Honor, that's all from us.
No. That's
All
further
right.
as well.
We'll go ahead and submit the order. You should be able to get it offline later today.
Thank you, Your Honor.
Thank you.
Thank
You have a great day.
Yeah.
All right. Is there anyone here on the scheduling conference docket?
Yes, Your Honor. I'm here on DC 24-01138.
Perinia versus Zepeda?
That's correct, Judge.
All right, what's going on with this one? It looks like you just submitted an agreed scheduling order.
Yes, Your Honor. Late Friday, an agreed scheduling order was submitted by plaintiff's counsel.
Okay, did you set this for trial on a Tuesday?
I'm not sure, Judge. I know we set it for next July. I'm not sure if that date was on a Tuesday or not.
Yeah, we set all our trials on Tuesdays. Let me see. Yep, it's a Tuesday. Perfect. All right. Rhonda, are you there?
Yes, Judge, I'm here.
I'm going to set this case for trial on July 22nd,
Got it.
and I'll sign the scheduling order right now.
Do we have a mediator?
We do.
Yes,
Lexa, go ahead.
Yeah, I'm sorry. Yeah, we agreed on a mediator also on Friday.
Yeah,
Got it.
Alexa Ald.
Got it. All right, thank you.
Oops. All right. Anyone else here on anything else? Mr. Villarreal, let me see this.
Yeah, I was here, Judge, on that scheduling order. That's all I have today.
All right. You have a great rest of your day.
Thank you.
Is there anyone else here on anything? Looks like nope. Mr. Haygood, are you here for something?
I was here for that same matter. It was just the exact same thing on the plaintiff's end, Your Honor.
Okay, great.
Thank you.
All righty. All right. Sam and Ways, are you there? So Rhonda, Tony, our next hearing's at 11. If you want to sign off, I have a bunch of orders I need to sign. I'll get those signed now. And then Sam and Ways, are you there? Okay. Let me go ahead and go over some things with you guys real quick. So Sam, I guess you're ill or something, is that right?
Yeah, my brother came back from Austin and gave me something. So
Okay. Well, let me kind of go over the schedule with you guys real quick. Tomorrow we have a number of trials. I don't mind if you guys come in, just wear a mask, unless you're just deathly ill, but you guys can come in next week if you, I know Ways you had COVID, didn't you?
I'm already negative, but I have 10 interviews for OCI this week before Friday.
Okay, what do you have tomorrow?
I have 2 mid-size and 1 mid-whole and night.
Okay.
And possibility, yes, I got an interview from Bob tomorrow morning.
Okay. And Sam, can you come in tomorrow?
I'm feeling very unwell today, so we'll see about tomorrow. But I think by at least Wednesday it should be okay. But I'm just very fatigued and I had a fever this morning. So.
Okay. Well, if you're feeling better, I could really use having an intern in tomorrow. You're the only intern. So if there's any way you could come in, that would be great. And I don't mind if you wear a mask. Wednesday through Friday, I'll be gone. But I do have I've looked for some things for you to do. Let me kind of go over that with you. So Judge Craig, if you come in on Wednesday, she has hearings all morning that you could watch. So just come into if you are up for it, come into the courthouse on Wednesday morning, and she has hearings on Wednesday, and then she also has an injunction hearing on Thursday at 1. So you'd have stuff on Wednesday and Thursday. And then Judge Savas, are you writing this down, Sam?
Yeah, sorry. My brain is a little slow today. You said Wednesday at 4 for Judge Craig.
9.
Where are you?
So Wednesday morning at 9 with Judge Craig, there's motions to compel and a plea to the jurisdiction that she's hearing. And then on Thursday at 1, she has a temporary injunction. So you can come into the courthouse at those times to watch hearings. And then tomorrow we have 6 trial settings. So if there's any way you could come in, it would be great. That's the only day this week that I really need an intern, but so just let me know if you can come in. Okay. Sam, are you there?
Yeah.
Okay.
I'm sorry, I was just writing things down.
Okay. All right, guys.